Well, good morning. My name is David Topor. I am an independent financial advisor. I'm not a CFP. That's a whole different thing, but I am a fiduciary. I've learned in my years of practice that when you deal with clients as a fiduciary, you have to do what's in their best interest, always. And so in that capacity, I've learned that estate planning and how you set up your beneficiaries is critical to serving my clients well in that capacity as a fiduciary. So I've learned early on that you've got to align yourself with good people that you can trust, that are approachable, and so that's why I work with Courtney. She and I worked with several clients in the past, with special needs trusts, with veteran trusts, with revocable living trusts, and with just the general powers of attorney, what have you. And we've learned that you just gotta have to be there to listen, because everybody in this room is different. Everybody has a different family dynamic. Everybody has different asset levels, different needs that they need to be addressed. And so we love doing this kind of thing. It all starts with education. That's why we jumped at the opportunity to be here. We believe in the two-professional approach to estate planning because there's legal aspects and there's financial aspects. I'm not licensed to talk about the legal. That's where Courtney comes in. Courtney's not licensed to talk about the financial. That's where I come in, okay? And so that's why we're gonna break up the presentation. She's gonna start with the legal start. She's got a lot more to talk about. Books have been written, seminars have been given. In fact, we're going to a seminar that's going to be a 2-day seminar about advanced planning because the laws are always changing and you have to keep on top of things, okay? So we are associated through the estate planning source. That's how we met, okay? And that's who helps us serve our clients. They've got a great portfolio of things that they can offer us to offer our clients, and that's why we love them. So anyways, I'm going to hand the mic off to Courtney. She is a UT grad, okay? She's got 2 young kids, and so she knows how to handle disorderly people, okay? So just so you know that.
As David said, I graduated from UT College of Law in 2009. And then starting in about 2015, I started focusing my practice on estate planning. When I got into law, I knew I wanted to help people, but I didn't quite know what that was going to look like. And so I went through several different things, and then actually got started doing the veteran trusts that David mentioned. And it was just amazing to realize how much estate planning can help people. And I think that estate planning is so important just because it gives you peace of mind, and setting out your wishes ahead of time can give your family peace of mind. And I know that so many of us, that is one of our greatest wishes. So, what is estate planning? It's how you pass your property from your generation to the next one. And it can be called multiple things, family wealth planning, things like that. But it's how you're going to pass what you own to the next generation. You might say, but I'm not wealthy. We've talked about trusts and trust fund type things. And when I hear trust fund, I think, New York City, penthouse. But estate planning is for everyone. If you own anything, you need an estate plan. If you have people that you love, you need an estate plan. So it is for everybody. The goals in estate planning, we want to help you to keep your hard-earned money. There are lots of things, especially as we age, that cost more and more. We want to help you to keep your hard-earned money. If your goal is to pass that on as an inheritance, you need to have ways to set that up. If your goal is to spend all that money you worked real hard earning, that's another estate plan. It's just whatever your goal is. You want to protect your family from estate recovery with TennCare. You want to be able to control your assets. Again, You worked hard for your stuff. You want to keep it and control it. And again, it's that peace of mind that you know that you can do with your stuff what you want to. So let's look at some of the different estate planning options that relate to your family's wealth, your wealth, and keeping things protected and protecting your family. So there's 4 common ways that you can pass on your estate to your loved ones. One thing is to do joint tenancy. So if you're married and you and your spouse own your bank account together, both your names are on there, that's a joint tenancy. So when one of you passes away, the other one's already on there, that's a joint tenancy, and so your bank account passes to your spouse automatically because they are a co-owner. Same thing with your house. If it's owned by both of you, that's a joint tenancy. Another way is to do a pay on death or transfer on death. Again, bank accounts oftentimes will let you do this. We can't do this on real property in Tennessee, but lots of other financial products you can. You designate, this is mine while I'm alive, and when I pass away, I want it to automatically go to my child, to my grandchild, to my spouse, to my sibling, whoever. So that's a contract between you and the bank or you and the financial institution, whatever product it is, and it automatically transfers. So that's another way that you can do your estate plan. A very common one is your last will and testament. That's a legal document that is written. There's multiple ways you can do it, but after you pass away, someone takes your will to probate and probates it, and you've put your instructions in there as to who gets my stuff once I'm gone. Another option is a living trust. And a living trust is like a bucket where you put your stuff, your assets, and you have instructions, very similar to a will. So you've got instructions on how things will be distributed after you pass away. But with a living trust, you can still control all those assets while you're alive. And it goes into effect immediately, whereas a last will and testament doesn't go into effect until you pass away. Now there is a 5th way, and 70% of Americans procrastinate until it's too late. So if you don't have an estate plan, don't worry, you do. The state has it for you. In Tennessee, we call it intestate succession. It is a cookie cutter. It's a law. It's a whole section of the Tennessee statutes, and it says when you pass away, who gets your stuff. Now, that's going to rely on it being, your family being a perfect, straight line, no changes coming into your family, no divorce, no adoption, we were raising my nephew, so he's like a kid, he's like my child, but, there's no legal document attesting to that, and so under the eyes of the law, they're not your heir. And then also, if you're married when you pass away, there's a spousal election, and then there's what would go to your children. So you may assume, okay, so I bought this farm before I got married. We never put, spouse's name on it. And then we had 3 kids. So when you pass away, it automatically goes to the spouse and the 3 kids. You might have thought it was just going to go to the spouse. Well, what if something happened and the 3 kids decide they want to kick mom off the property? You got to look at where the law says it's going to go. So if you don't have an estate plan, there's something out there. But it's best to make sure that you take the steps to do, make sure that your estate plan is going to protect your assets and transfer your wealth and your assets from your generation to the next one. So some of the considerations in estate planning are going to be cost and time. It's all going to cost something in dollars and time. If you have a will, it has to go through probate. In Tennessee, the minimum time for probate is going to be 4 months, and that's once you actually get everything filed and started. Often it's going to take at least a year to probate an estate. An estate through probate is open to the public. If you're bored one day, you can go down to the courthouse and say, I would like to see this probate file, and you can see what John Doe left in his will and who his executor is and who gets his stuff, if you're poor. So another thing that I haven't touched on yet, but we will, is conservatorship. This is something that happens when you're still alive, but it can result in you losing control of your property if you haven't planned ahead to put documents in place to help with those transitions. So other considerations are having a will or not having a will. There have been multiple options on how you can do your estate planning. Relying on joint tenancy, there are pitfalls that can be involved there. And then also not appointing a guardian for your minor or disabled children. If you have minor children or if you're raising grandchildren that you have legal custody of. What if something happens to you before they've reached the age of majority? Estate planning can help you to set out who you nominate to take care of your children or your grandchildren, or if you have disabled children who need a permanent caregiver. You can set that up ahead of time so that the family isn't suddenly going through grief and the turmoil of finding a caretaker and determining who's going to be the provider for this disabled individual. Another thing to consider, and this is more of either David's side or getting a CPA involved, are the tax considerations in estate planning. You're going to have capital gains, potentially have capital gains taxes, federal state taxes, state inheritance tax, gift tax, and these tax laws are constantly changing. Several of them are going to sunset in 2026, and there will be new thresholds. Is your estate big enough to have an estate tax? Is it not? That's something to look at with your attorney and financial planner. Okay, so that was the big overview. Now to get into a little bit of the nitty gritty. What is probate? So if you have a will, or if you don't have a will, so this is that state plan as well, you have to go through probate. It's a court process that validates your will if you have one. It passes ownership of your property to your heirs through an executor or an administrator of your estate. It clears title to any of your assets, and it settles your debts. So if you owe money to anybody when you pass away, they can file a claim against the probate or against your probate estate, and your administrator or executor has to pay that. There's several options in Tennessee. If when you pass away you have real estate and non-land assets, then you go through what's called full probate. That's the one that takes minimum of 4 months because there's the 10-care estate recovery time and the debtors period where they can file claims against your estate. You can also file a small estate if you have no real estate, no land, and the total value of your estate is less than $50,000. Then if you only have real estate, there's another option called muniment of title that just sets out clearly who owns your land, your real property. Some of the disadvantages of probate, like I said, it can take a long time. 4 months is the minimum, but really 12 to 18 months is going to be more realistic. It typically consumes, you've got to pay somebody. Even if you don't hire an attorney, you've got your administrator who's going to have expenses. And so it's probably going to consume about 4 to 10% at least of the gross estate. Like I said, probate records are public records. Anybody can go down to the courthouse at any point in time and request a probate file and just page through, thumb through it, see what's going on. And because it is a court process, it can invite contest and divide your family. Not always, but it can. Some statistics from AARP. The next generation will lose more than $2 billion annually to probate, just in those attorney fees and estate taxes and those kinds of things. Conservatively, 8 to 10% of every estate will be consumed by probate unless those proper steps are taken. And yeah, the way that those amounts are being eaten up is the court costs, accountant fees, because you've got to file taxes on the estate, the attorney fees, travel, time off work, all those kinds of things. All right, so that was if you do or don't have a will and are going through probate. Now, a will only takes effect after you pass away. It cannot do anything for you while you're alive. So that's where conservatorships come into place. If you were to become incapacitated, meaning you can't make your decisions, either about your health care, your personal care, your financial obligations, any of those things, there's a legal process where you can be declared legally incompetent, and the court can strip your rights. So it's essentially rewinding the clock and becoming a child again, because someone is appointed as your conservator, your legal authority for making sure you go to the doctor, making sure that, you know, they get to say which healthcare options, you know, you are receiving. They get to say where you live. They get to say what you can and can't spend money on, things like that. And anyone, even a stranger, could be appointed as your conservator to take care of your property and your person. Some, you know, famous cases that have been public lately have been like the Britney Spears case, where, you know, she was fighting a conservatorship. They can be very, very difficult to fight. Anyone at any time can apply to decide your life decisions if they think that you're mentally incompetent. Now, it is a legal process. It has to go in front of a judge, go through a court and everything, so I don't want to scare you too much on that one. But there are documents that you can set up and steps you can take to protect yourself against having to go through that conservatorship proceeding. So if you make a decision to set up the necessary forms while you're able to, you can establish a durable power of attorney that is durable even after you become disabled or incompetent. So that sets up the person who is going to manage your financial and contracting affairs. You can set up a healthcare power of attorney so that if you are unable to make your own healthcare decisions, this is who you want to make those decisions for you. You can even set up a nomination of conservator. Now, it would still have to go through a court process, but let's say you've got 2 children. One, you know, is very nurturing, very caring. You feel like they're gonna, you know, look out for your best interest. Your other child is maybe a little more self-focused. Maybe isn't necessarily going to look out for your best interest. They might be looking at their inheritance interest, that kind of thing. You know, you want to pick which one you want to be your conservator. And so you can do a nomination of conservator. And if it reaches that point of going to the court process, then whoever has, who's, you know, filing it can show the judge this document, say, look, when they were of sound mind, they said they wanted child A to be the conservator. This is the one that they want to take care of them. And the judge will take that into consideration. So a good estate planning package is going to contain those documents, is going to have those conversations about, you know, how you want to live out your life. That way you can decide who's going to make the decisions if and when you become incompetent. So when this is personal on me, when I put together an estate plan, grab my visual aid here. This is the lovely document that you get. I put it together in the order of need, so that hopefully you can access things just kind of as it goes. So the first thing that is needed is often your power of attorney, either springing, durable, or limited. And that's where, again, you talk with your attorney about what are the needs that you have. But a power of attorney is only effective while the person is alive. It gives someone else the power to do what you could do. So once you pass away, you can't sign contracts or do things like that, so they can't either. Next would be the nomination of conservator. You're still alive, but have reached, you know, a point of some sort of mental incapacity or physical incapacity. Next is the advance directive. This is a healthcare power of attorney and a living will. Tennessee has combined the two into a single document, the advance directive. chances are your doctor hands you one every time you go to the doctor right now and says, hey, do you have your advance directive? That is the document that's going to appoint the person that you want to make your medical decisions if you're not able. This one only goes into effect if you're not able. And it also sets out what your wishes are. This, I think, is one of the kindest documents that anyone can generate for their family. Because no one wants to have to make that decision of, you know, well, would mom want to be on a ventilator? Or would she want this treatment? Or would she want that treatment? It's your body, and it's your life. And so you get to make those decisions. And it's so kind to be able to have that written out on paper so that your family doesn't have to wonder. Because in that situation, you know, they're already going to be extremely emotional, and nobody wants to fight over that either, that kind of thing. So then the last document is going to be your last will and testament or a trust, because those are things that would go into effect after you pass away. Now a trust can be a living trust, can be in effect this entire time, but the distribution in it goes into effect after you pass away. Okay, so earlier I kind of ran through the 4 ways that are common for transferring your assets to the next generation. So we'll dig into those just a little bit more. So the first one was joint tenancy. That was the one, like I said, either your bank account or your house is in like yours and your spouse's name. Could also be like your name and your child, you and your sibling, you know. It's just you and another person are on the title together. And so as long as there are rights of survivorship with it, then the first one who passes away, you don't have to do anything. The other person on the account still has full control over it. It automatically just completely passes to them. But it does not avoid probate, because when that second person passes away, there's not anybody else listed on there. So it delays the probate process, and you do still need to have something in place that designates who gets whatever that asset is. Capital gains taxes are not avoided. You may end up with unintentional gift taxes. This especially comes into play with like if you put you and your child on an account together, that kind of thing. Property that's titled jointly is subject to court judgment or creditors. So if your joint owner is sued or gets a divorce or files for bankruptcy, then their part is definitely accessible. And if it's all commingled, then you may end up losing part of your asset. There's also control issues with co-owners. You know, if someone else's name is on the title to your house, then you have to have their permission to sell the house. So again, if you were to put your name, you know, your child's name on the house to be like, okay, we're going to pass it on to them, but then you realize you'd really like to downsize to a condo, but they don't want to sell the house. Well, then we have a whole fight on who really gets to say, you know, do you get to sell the house or not? Because you can't sell it without their signature. All right, the payable on death or transfer on death designation. If you only have a few assets, then this may be the estate plan that you need. If you've got, you know, a couple of bank accounts, brokerage accounts, and then only like 1 or 2 beneficiaries, you know, you have an only child, you've got 2 kids, you know, that kind of thing, then that may be all you need for your estate plan. Now, like I said earlier, most states don't allow a pay on death or a transfer on death deed for real property, for land and house. Tennessee specifically does not. Some states have them, they're called a ladybird deed, but Tennessee does not. So the next way of transferring your assets to the next generation is a last will and testament. It may cost less upfront, not may, it will cost less upfront to establish a will than, say, a trust. And you can express your desires for how you want your assets distributed. But there can be lots of disadvantages, including that probate literally opens it up to be contested. Anybody can come to the probate hearing because you have to send out notice to all of the legal heirs that this person has passed away, so they know. So even if you have a child who's been estranged, then they still get notice. They can come and say, well, I'm a kid, I deserve X% of the estate. You also have to publish that, this person has passed away, and so creditors can file claims. So yeah, it's easily contestable. Having a last will and testament does guarantee that probate will occur, because that's the only way to enforce what's in the will. And I'm even guilty of this. Don't believe it when you hear, oh, probate's easier and expensive in our state. I have said that phrase, and it has now turned around to bite me. Sometimes probate can be easy. Sometimes probate can be inexpensive. But it also depends on what the stack of papers on the judge's desk looks like. I have an estate that I opened recently that, I was like, oh, it'll only take about 2 weeks, because about 6 months ago when I had opened an estate, it only took about 2 weeks for me to get the letters. It took 6 weeks. And so this one had, some investments in the stock market, and so they were watching the stock market go like this, going, when is the judge going to sign it? When is the judge going to sign it? Because they couldn't do anything with those stocks because they were still in the name of the deceased individual. They were going to be in the name of, the person who was probating the will, but it wasn't there yet. And so they had to sit there and watch their inheritance just do like this with the stock market. So it might be easy, and it might be inexpensive, or it might not. In fact, it's proven to be costly and time-consuming and public. Your will is only valid when the probate court approves it. So there are legal requirements for a will in Tennessee. So if you just type something up on your computer and you sign it, that might not fly in court. In Tennessee, you've got to have 2 witnesses, and it needs to be notarized. Now you may be able to write it in your own handwriting, but again, you've got to meet all these specific requirements. And then especially if, somebody comes in to contest it. A sibling comes in and says, that's not their handwriting. Says, somebody else was influencing them when they filled that out. So the court is going to have to approve your will and then enforce your will to distribute your assets as you have wished. And again, it doesn't provide any kind of protection for you while you're living. You can change it as many times as you want while you're alive, because it doesn't go into effect until you've passed away. The 4th option is a revocable living trust. This is an estate planning tool that's gained popularity recently, because it kind of puts a lot of these other options together into a nice package. It does avoid probate and conservatorship, and can avoid conservatorship when done properly. It protects your privacy and preserves your assets and special beneficiary designations. It's revocable, so you can change it any time while you're alive. And it gives you the ability to preserve the estate tax exemption for when the first spouse passes away. So another option is an irrevocable living trust. Now, this is going to be the type of trust that people think of with like tax shelter or sheltering assets so that you can apply for certain government programs. Again, we're going to avoid probate and conservatorship, protect privacy. Now, the difference on this one is that being irrevocable, it takes away control from the grantor, the person creating the trust. Oftentimes these are going to be called like 10-care trusts, or I'll reference back to the veterans trusts. And so with 10-care and with the veterans aid and attendance, your asset level, the value that you own has to be at a very low threshold. And so if you anticipate that you are going to need those kinds of services, either aid and attendance or 10-care, then you can set up an irrevocable trust. It takes your assets and puts them in a bucket over here, but someone else has to be the trustee. It can be an adult child. It cannot be your spouse. It could be an adult sibling. It could be, a professional fiduciary. But you do lose control of that asset for, I believe, 5 years for the VA. Is it 5 for 3?
3 for the VA,
3 for the
5
VA, that's
for the
right.
state.
So the look back period is either 3 or 5 years, depending on which organization. So if you're looking at TennCare, you know, it's got to be set aside for 5 years before TennCare won't look at it. So you have to lose control of that asset for 5 years. But it protects your spouse and your family from spend down provisions. Because the other way that you qualify is you spend until you reach that bottom threshold. And so it's a way to preserve the inheritance that you have worked so hard to pass on to your family. That's one that, you know, you would want to speak with an experienced attorney and financial planner to set that up and navigate all of that. So we've talked a little bit about the trust, and it's important to know who's who in a trust. So I've talked about the grantor. That would be the person setting up the trust, and they grant the assets to the trust. So if I set up a trust and I put my house into the trust, I'm the grantor. The trustee is the person who controls the trust. With a revocable living trust, frequently it's you. You can have full control of all your assets while you're alive, but you get to go ahead and nominate your successor trustee so that if you are unable to manage your affairs, or once you pass away, then your successor trustee can automatically step in and manage your affairs, manage your property, manage your assets. Then beneficiaries are the people who benefit from the trust, your heirs, the people who are going to receive property after you pass away. So in a revocable living trust, the same person can be all 3 of those things, because you're a lifetime beneficiary as well, because you're in control of the assets. You can live in your house, you can spend the money in your bank account. In an irrevocable trust, the grantor cannot be the trustee or the beneficiary, really. So some differences between wills and trusts. A will is going to have to be probated. That means we've got a court, we've got a delay of usually 1 or 2 years, we've got public disclosure, there's going to be some emotional impact on the family potentially. You're going to be looking at court-appointed guardians and or conservators. There's expensive probate fees. You got to pay to open the case, and then depending on how long it's in probate court, you know, you're going to have additional fees there. And essentially, it's totally public and court-controlled. So with that, you have your document, your will, goes through probate, and then it gets to your heirs. With a trust, the court's not involved. It's probate-free. It's delay-free because everything is already in effect to just go immediately. It can be hassle-free. There's typically not any unnecessary taxes. You get to appoint the guardians. You get to appoint the conservators. It protects you during your lifetime because you still have control of your assets. A big one is the no contest clause. You can put in there, you know your family, so we all have somebody in there who's gonna poke the bear, gonna pitch a fit about something, and so you can put a no contest clause in there, and you can say, hey, I know that so and so is gonna pitch a fit, so and so is gonna cause a problem. This is what they get. My daughter's dance teacher has a phrase: you get what you get, and you don't pitch fit. So you can put that in there so that you go ahead and take care of that. That way you then don't have multiple family members arguing over trying to get all of that set up. The other great thing about a trust is it's totally private and it's family controlled, unless you choose to appoint a corporate fiduciary. But even that is your choice. So it really shields your assets from that public knowledge and that court control that a will and probate would have. So, not all living trusts and estate plans are created equally. You get what you pay for, sometimes. So, with any of these estate planning options, you can do it yourself, or try to, and you might do it right, or you might not. So that's where I have the little sand bucket there. You know, you might set something up that's akin to a Dollar Tree sand bucket. You know, you can go through a trust mill. Those are really popular online. You can go through certain websites that you know, you type in your information, it generates a document for you, but it's going to be very cookie cutter. It's not going to be customized to you and your specific needs and situation. You can call your cousin's neighbor's boyfriend, who is an attorney in DUI court, I don't know, and ask them to do it. And they can draft you legal documents. That's fine. They may not really know what they're doing. They might be looking at the forms book down at the law library. And again, so it's not going to be tailored to you specifically, or they're not going to have that experience to know what really needs to be in there versus what doesn't. Or you can, you know, you can use what David and I have been doing, and that's collaboration between experienced professionals. An experienced attorney who does estate planning, is familiar with the estate planning world, and a financial planner who knows what those tax implications are going to be, how to best, you know, leverage your assets to be able to pass on the best inheritance to your family. Those are going to be your options. So yeah, you get what you pay for sometimes. All right, now I'm going to turn it over to David, and he's going to tell you a little more about that.
One of the things I want to talk about when I brought up, first off, does your brain hurt as much as I do after going into that world of, yeah, it's complicated, it's complex. You need to get a professional who's got the experience to do it and the time to listen and explain, because it's huge. I'm going to bring up 3 mistakes that I see that I was reminded of. Number 1, Grandpa dies. Everything's in Grandpa and Grandma's name. Grandma gets everything. No need to probate the will because, A, they didn't have much except for the farm. Okay, Grandma lives another 20 years. The farm has grown in value. Okay, now she passes away. They never probated Grandpa's will. Okay, they didn't know they had to. Do they have to before they sell the house? Yeah. They have to get, especially if it's in both their names. Okay? So, check your deed. If you've got a situation that's pretty close to that, let's take care of it now while Grandma's still living. Okay? Let's go through the process to do that. Okay? The other part was, you guys all know Red Fox, right? Red Fox died how many years ago? Okay? His estate has not been probated, okay? Because he owed a lot of money. He had a gambling problem, okay? And so the people at the casinos or wherever want to get their money. And he's got a great story that his family probably could sell, okay? That's why you haven't seen a TNT special on the life of Red Fox, okay? Because they can't sell the rights, and so it's just sitting there in limbo. Okay, it's crazy, but that's what happens when families can't get together. The third thing is going to be directed to your situation. Right now, who knows what the lifetime tax exemption is for federally for someone if you die? What part of your state is taxed at 40%? Okay, right now it's like $12.5 million, okay? Now that was all put together with the Trump tax cuts that came a few years back, and they're all set to expire. So that $12 million is going to be reduced, cut in half, to like $6 million. So some of these farms that are worth a lot of money, you're seeing people scramble right now, setting up trusts to shelter that, because if Dad dies, you can take his $12 million, put it in the trust. Okay, as long as Mom doesn't use that money for whatever, investing or whatever she can, that money's got to sit there safely earmarked for when she dies, and that's how you can preserve. That's how you can preserve that. So she can live on, let's say it was $20 million. She can live on the $8 million that's left over from the 12. Okay. And the tax rate is 40%. Okay? 40% of that money. So that's why the exemption's key. And so, you know, if someone, I mean, the last time Congress lollygagged about the estate tax, guess who died that year? George Steinbrenner. The Yankees passed from George Steinbrenner to his son, and he had to pay 0 estate tax. Okay, you think they're going to make that mistake again? No. Okay, that's what we call in our world legislative risk. There's legislative risk. Okay? The third big thing financially, as far as estate planning goes, is IRAs. Okay, anybody hear the Secure Act came out a couple years ago, 2020, and then they amended it because they found out they made a mistake and they wanted to get at your money quicker. Okay, the Estate Act, if you have an IRA and you pass away, it can go to your wife and she can't, or your husband, and the spousal doesn't have to spend that money down any quicker than they already are. Okay, but if you pass it to your kids, okay, they have 10 years to pay tax on that money. 10 years. It used to be they could hold it for the rest of their life. They don't need to take out a requirement of distribution. So I had a client, situation was, the son was an attorney making $500,000 a year, inherited a lot of money. Okay, almost 50% of that money gets to go to Washington. Okay, so yeah, there are implications, and guess what? That rule could change tomorrow. Maybe it's going to be 5 years. I don't know. We don't know. That's legislative risk. It's got to be looked after. Okay, so funding your trust. Okay, I talk to a lot of clients. Oh, we got to trust. Okay, you got to trust. Yeah. What does it say? I don't know. Man, nothing gets me upset more than that. I say, have you funded your trust? What? Have you funded your trust? What does that mean? Well, the trust is only good for what's in the trust. Okay? So most lawyers, and not to put lawyers down, okay, but we know we're on the rung of the ladder, present company excluded. Okay, there's car salesmen, okay, there's Amway salespeople, and then there's lawyers. Okay, just kidding. We just got to break it up a little bit. Anyway, I say that because in there, a trust that is not funded is not valid, correct? So they'll write in there, we have placed $10 in this trust, and the rest is going to be funded when you die through a pour-over will. Okay? Now we looked at that list of the things that you avoid when you have a trust. That's only for the stuff that's in the trust. Okay? Most lawyers, correct me if I'm wrong, lose money when you don't go through probate, and so when they put together a probate document, okay, they're going to say, you don't have to worry about it, it will fund when you die. Well, all those great things that you're trying to avoid won't be avoided. And you just spent $5,000, $6,000, maybe $10,000 to protect $10. How does that even make sense? So as a fiduciary, I get into the trust. I look at it and see what's going on here. So I may be sitting in the room right now with people, and some of you have trust, you never looked at it, okay, I got that taken care of. But do you? Because funding is the most critical part, okay? Trusts are only protected the assets that are owned or assigned to the trust, okay? There's a list of them, okay? What kind of financial accounts are used? All those bank accounts, non-qualified money, annuities, what have you, okay? Retail real estate assets, multiple states, okay? Every state has different laws. If you have multiple states, that means multiple probate, okay? So if you have places in Florida, places in New York, you got a ski lodge in Colorado, something happens to you, that's going to delay it, okay? Who's going to pay the utilities on those houses? Who's going to pay the property taxes? Who's going to pay the HOA? Okay, all those are expenses. If it's in a trust, the trust can pay. The trustee has the ability, the day you die, to pick up that pen and write that check to keep those things taken care of, okay? And sell it. You can sell it the day after you die. You can sell the property, okay? They have the right. They have the right. There's nothing that's going to hold them back if the property is in the trust. They can trade that stock if it's held in the trust the day after you die. Okay, these are what she's talking about. These are real life examples, and they happen all the time. Okay, reassign tangible assets, jewelry, art, coins, that kind of thing. Gun collections. Your guns can be in the trust, and they can go to your grandkid the next day. Okay, not so. Not so when you have to put it in the probate process, and then you got to list your guns in the probate process. That's a whole other thing. Okay, how can you fund it? Life insurance. Did you know that your life insurance, if you have $1 million policy, that's included in that, your, what the government says is your estate? Okay, a lot of people don't realize that. So even if you give it to somebody else, it's still included in that exemption. So you have to be careful having too much insurance or not enough, right? As a beneficiary designation as well, I see this a lot with special needs trusts, okay? Parents have a special needs kid. They want to make sure that there's going to be money for it. The most efficient way to do that is through designation from a will. Gifts from other family members, okay? That's especially true in, let's say grandma and grandpa want to give the $14,000 a year to their grandbaby who's got Down syndrome. Okay, well, they can stay within that tax exemption. They can give that 14 or 15 or whatever it is. Every year it changes. Every year they can gift it over, no tax implications, put it into the trust. Nobody can touch it. It's not, you can't buy a new car with it. It's going to be there for their baby that they love and they want to provide for. Okay? You can transfer funds from existing accounts. You can't go into Regions Bank and say, hey, I've got a trust, change the name of this to, you know, the Smith Family Revocable Trust. Can't do that. You're going to have to get a whole new trust account, but then once it's open, you can transfer money over. That works. Quick claim deed property, that's key, okay? Cost $100 to do that. A lot of people delay that. That's crazy, crazy, crazy. You don't lose ownership, because when you own a trust, the trust is here, you're the grantor, you're the trustee, and you're the beneficiary. Everything in that trust is still to your benefit. Okay, you don't lose any control. All you gain is protection and peace of mind. And then you get a letter of assignment for tangible property. This works with all those other things I talked about, the gun collection, the coin, the art, the jewelry, all that kind of stuff. So all that's in there, and then you can't contest it, okay? Now, taxation for trusts. A lot of people say, okay, look at that. So right there, your income tax. So if you earn $5,000 in a trust, okay, if you earn $5,000 outside a trust, you're going to be taxed at a low, low rate. Right here, the first $10,000 is going to be at 10%. The second $2,000 is going to be at 24%. See how they did that? They compressed it down in the trust. So there is a disadvantage to trust, and this is it, how it's taxed, okay? Because you can't take your exemptions. So you got to be careful how you do that and what it looks like, okay? And that's why tax deferred things are very advantageous, and so we can talk about what those options look like. But I want you to know that we're here to educate, the good, the bad, the ugly. We're gonna give you the honest answers, okay? We like to keep things organized, okay? You see that little blue book there? That's just an example. You can get those as staples. So if you have one, put it together, get it together, hold it for your family. We recommend that you have 3 copies. 1 that you can work with. Number 2 that you've got in a safety deposit box just in case the house burns down. And then I like and help people set up online access in a protected area because it's so critical to do that. So there's a lot of irrevocable options. We talked about that, and we could probably put a presentation on about these three right here. Miller Trust, Final Expense Trust, and Medicare compliant SPIAs. I help clients with these all the time for people who are in that spend down provision, who need the Miller Trust because they see that they have Alzheimer's and it's progressing, and they can't afford looking at $6,000, $7,000, $8,000, $9,000 a month for care. They work their whole life. What's going to happen with the healthy spouse? You know, they're in a scramble. And so there are ways that we can, financial professionals and attorneys, help people avoid that kind of stuff. You know, we work together on some of those, and it's difficult to do. Sometimes it's too late. Sometimes it's too late. And so you got to be thinking about what that looks like, because yeah, there is a 5-year look-back period for that. For the VA, I'm more familiar with the VA independence pension. 2018, they changed it, and they instilled a 3-year look-back period. But there's good help, and any veterans in here, any widows, surviving spouses, we can talk about that too, and I can help you look through what that looks like. The 4 P's of estate planning, you got to protect. That's what it's all about. It's in your financial best interest to protect your hard-earned money, your money and your family's money. I look at them as one and the same. If you can avoid probate, we recommend that you do, because it's nothing but a headache. Okay? Sometimes it's easy, but more often it's not. Privacy is key in this day and age. People are stealing identities. I just talked to a kid. He did some yard work for me yesterday. He can't get a bank account because his identity was stolen. And so I had to, it was crazy. And then peace of mind, just knowing that it's taken care of, that your affairs are in order. It's when I sit down with a client and we do this process, they come in here like a snare drum. They're all tense, and right? They're like they don't want to make a bad decision or whatever. And then just through the process of explaining it and what's going on, and as we work through the different stages of it, it's just, you just see that there's this relief that they have, and the peace of mind is tremendous in doing it all. A couple of things I want to talk about, because people ask me all the time, well, listen, what about beneficiaries? What about, my will says this, and my beneficiary says, that. So let's say you're supposed to give 50% to your 2 kids, but you only put, when you wrote your insurance policy, which is the bulk of your inheritance or whatever, you only put 1 kid on because the other one was ticked you off and you didn't want to put him on your insurance policy. And they said, oh, he'll share. Well, here's the thing, that any kind of a contract you have is going to trump, okay, your legal documents. Okay, so if your IRA designation only lists 1 of your kids and your will lists all 4 of them, okay, guess who's getting the money? The 1 kid on the beneficiary. Okay, how about you get married 3 times and you have a $100,000 IRA from the first job that you owned, and you never changed your beneficiary from your ex-wife to your subsequent wives and kids, and you die, guess who gets it? Even if she's dead, it goes to her kids if you don't change it. So beneficiaries are really important, because it doesn't matter what your will says, you have to align. And there was another point that I wanted to say about that. Blended families are huge. Huge. You're lovey-dovey right now, but something happens and you pass away and your lovey-dovey becomes lovey-dovey with somebody else. She can intentionally disinherit your kids. Even though when she was lovey-dovey with you, she said, oh, don't worry, honey, I'll include them in my will. Well, if you get a trust, you can lock it in, and she can't do nothing to disinherit your kids, okay? So those are the three things. And again, our time has come to an end.